what's that? I saw on Instagram you posted that restaurant that you went to. What's
Palais Casablanca.
Yeah, was it good?
It was good. It was. I think I liked my husband liked some of the food a little bit more than I did, just because I'm not really big on lamb.
Oh, okay.
Which is like a lot of what's on the menu. But it was really cool. It's like, have you been on the inside at all? It's got kind of like tapestries and nice rugs all on the inside, so you feel like you're kind of in a tent, I think that's the point. And you sit on these like pillows on the floor. And we did this multi-course meal. He's been wanting to go there forever. And so we used to live like across the street, and so he's like, it's ridiculous, we've never been there. And so we did the whole thing, that multi-course meal, and the food was really good. I just didn't particularly like the last one that we got because it was lamb. But the service is really good. And I guess they have belly dancing there on Friday and Saturday nights. So I think that'd be cool to go back for. But I'd give it like 4 out of 5 stars.
Which restaurant is this?
Palais Casablanca. It's like down University, south about a mile.
And Bonnie Gray?
No, I'm sorry, other way.
Oh, south.
Yeah, and
oh, yeah. It's
well,
like just down here.
I've also just been really intrigued by it because it looks like, based on the outdoor decor, I was like, that's got to be really interesting on the inside. But I think in the summer you can smoke hookah on the patio, and then they said they have belly dancing and sometimes other dances too. So I think it'd be cool to go back with like, I think it'd be better with a group.
I have been there for drinks.
Okay. Yeah.
Yeah.
I think I
If
touched
you give
today
it a group, I
again.
think it's really
This shirt.
performances.
Still got some kind of.
I know. I stayed myself with instant coffee. Just that. Like, how do you even? My lunch is on my shirt.
I did the finger.
Whoa.
Right. Okay, everything's going according to plan. Excellent. So we're going to talk quickly, not quickly, but briefly about sort of the judicial opinion writing process, and that, again, we'll delve into more as we go through our simulated judicial opinion drafting process. But I wanted to sketch out some of the main components of that. And then we're going to talk about the Perry decision, the district court decision. And why do you think I wanted you guys to read the district court decision in addition to the Ninth Circuit decision? Any thoughts? Findings of fact? Pretty significant, right? And the court just takes a different approach than the Ninth Circuit, so it helps sort of flesh out the various possibilities in terms of what the Supreme Court might end up doing. So you have more options to reflect on by virtue of reading the district court decision. And it's also both decisions are really interesting moment in decision making and judging. And I think there's a lot of fodder there for discussion. We probably won't get to this till Monday, but then we'll talk a little bit about the motion to vacate and the recusal issue in the district court, and then we'll look through the Ninth Circuit decision. So let me go ahead and give you your copies of the Ninth Circuit decision. I don't know if you guys know this, but when you publish an article, they give you like 3,000 bound copies of your article. So I'm going to go ahead and give you guys these bound copies of my article. And so I think it's probably typical for professors to force you to read their scholarship. It's kind of maybe a dubious practice. But there's so much scholarship out there in more, shorter articles about what's going on with same-sex marriage litigation, and it's just, there's no way we could really cover it all. So I've just given you my work as not something that you should consider incorporating in your opinion or anything else, but as an example of a critical perspective on the doctrines that are being used by the courts. So there's the longer piece, which is sort of more doctrinal, and then this is a very short piece that talks just about what the Ninth Circuit did and its decision. So that's stuff that you can really have as a reference. Read the Ninth Circuit decision for class on Monday. The other stuff, honestly, you can read it or not read it depending on your interest, but it just, like I said, it gives you a critical scholarly perspective on kind of, how the courts are using this doctrine, this doctrinal framework in the context of the same-sex marriage litigation. Okay, so in terms of the stages of a judicial opinion, there's kind of two aspects. One is what happens at the court, and then one is what happens between you and your judge. And obviously, again, as with all the other topics we've discussed, there's sort of caveats, right? There are different procedures depending on the court and the judge. But there's some essential elements, right? So, the parties, as we talked about, first will be the filing of a notice of appeal, then the court will set, or really the briefing schedule will be dictated by rule, so then the parties will submit their briefs, and also whatever the record on appeal is. And briefs they may have different names in different courts, but basically opening, answer, and reply. So that's appellant, appellee, appellant. As you know, there can be amicus briefs as well for each side, and there's special rules about when those need to be filed. The majority of cases do not have amicus briefs associated with them, but of course in the Proposition 8 and Defense of Marriage Act litigation, there's, I think, a total of over 80 amicus briefs that have been filed. At some point, there's a decision made about oral argument, and again, there are different mechanisms for making this decision. It could be, where if either party requests it, oral argument is granted. It could be that there's a screening process by staff attorneys, by judges, by both, regarding oral argument. But at some point, it's either going to be oral argument or it's going to be, what in some courts is called a conference case, which means no oral argument. The judges just sit down together around a table and discuss the merits of the case. At some point, there's an assignment to a judge or justice. And honestly, that could happen here if it's just a matter of indiscriminately assigning docket numbers to particular judges. It could happen, here after the decision is made as to the relative complexity of the case, which is kind of what the oral argument decision means. And then there's sort of the bench memo, predisposition memo stage. And so a bench memo, your judge may want a bench memo on every case that is being presented in that particular oral argument term, okay? And so that's regardless of whether your judge is the authoring judge or not. They want to be prepared to participate in oral argument. So typically, if your judge is the authoring judge, the bench memo, they're going to want the bench memo to be pretty thorough. And you can sort of play this game when you sit and watch oral argument and see which of the judges is most invested in the questioning and guess maybe that's the judge that's been assigned the case. The predisposition memorandum, as I understand, is done as a matter of course at the Colorado Court of Appeals, and it's a recommendation, right? It's advising about what's kind of happening in the case, the merits of the argument, and then a recommendation that the decision should come out one way or another. And the bench memo can kind of serve the same function, but this, basically either becomes the majority opinion or it's going to become a dissenting, possibly a concurring opinion. Okay, so the sort of anticipation is that most of the time the predisposition memorandum will become a majority opinion, but obviously that's not always the case. So like in Vermont, you had a judge who was assigned, and generally regardless of what happened at the conference, that judge who was assigned to author the majority decision would circulate a draft. And then another judge would say, I think this comes out a different way, and they would circulate a draft, and then you count votes and see who comes out ahead. And then there's a lot of back and forth, a lot of times, drafting-wise, between the majority and dissenting opinion, okay? Then you have oral argument, or, as I mentioned, the conference. And so if they have oral argument, the judges will typically put their heads together also after the oral argument happens. And if there's no oral argument, then they'll just go They'll conference the cases. And again, that's kind of where this decision is made. Who has the votes? What's the majority approach going to be? But it can go back and forth. And then you'll have like the holdout judge or justice. Justice typically, this happens more, I would guess, the Supreme Court level, but who's sort of, who's going to win my vote, right? Kind of holding out for that particular judge or justice to be persuaded, okay? Any questions about that basic sketch of what's happening at the court level? Alexis, or no? No, okay. So then, I'm going to give you, again, a rough outline about the process as between you and your judge. There are obviously variations to this. It would be pretty unusual for you not to have an initial conference with the judge, right? So the judge says, I've been assigned this case. I'm inclined to affirm. I'm inclined to reverse. What the grounds are for that, okay? My advice then is you go to prepare the case, and you might have some, maybe there's been some earlier memoranda, a bench memo, earlier draft, there might be earlier materials that you need to talk about. My advice, before you read the briefs, is to read the underlying decisions. Decision or decisions, if there's a written decision. Why? Because I kind of trust the courts more than I trust the litigants in terms of their representation of what happened in the case. I mean, sometimes you'll read the briefs and then you'll go read the underlying decision and there's a real disconnect. And obviously it's the obligation of the parties to sort of try to present things in the light most favorable to them, but I feel like this is a good grounding. And then I would take a look at the briefs, and at that stage you can ID the issues on appeal. Again, you would think that would be self-evident. It's not always self-evident exactly what issues the parties are raising, right? ID the standard of review. ID is my shorthand for identification. The standard of review for those issues on appeal. Are there any fact or record problems? Right? I gave that example of, do we know whether the relevant portion of the record is the hearing on a particular issue or whether it's the entirety of the trial court record, right? Does the appellate make a critical factual claim without a citation to the record? For some judges, that person's out of luck. For other judges, you have to figure out, okay, where is this? What exactly is going on here? And then legal. Are there legal issues? It's really nice. One of the great things about being a law clerk, and one of the reasons why you can be a law clerk right out of law school, is that the parties, the underlying decision, and not in your case, but typically the underlying decision in the briefing sets out and frames the issues, right? But that doesn't mean you can stop there. So, your judge may or may not say, I don't think this is the correct reading of Celotex or whatever the case may be. But you want to kind of pinpoint the key legal claims. So not the case they cite for the standard for summary judgment, right? The key legal claims, and conduct independent research as to all of these to the extent necessary. Supreme Court clerks are going to have a lot more time to do this than appellate court clerks, who will have more time than trial court clerks. Okay. And obviously we're going to follow this practice in our class, outline, and then draft. And really, you're conferring, depending on your judge's style, at all those different points, or none of them. The judge wants to be really independent and just go ahead and submit a draft. In terms of the style of the opinion, you obviously want to look back at other opinions your judge has written. The judge might give you a notebook full of his or her opinions to kind of give you a sense of how they like to write or what have you. Okay, and then again, there's variation, but the basic components of a judicial opinion. I mean, for example, again, in Vermont, we had a very nice sort of style manual just for the Vermont Supreme Court that talked about exactly how you should generally approach it. But, you know, in the introduction, you need to introduce the parties, the essential dispute, and typically the outcome. For the reasons stated below, we affirm, we reverse, we remand with instructions. Okay. So the person who rushes to the courthouse to get the first copy of the decision that's been issued that day can look at the first paragraph and know whether they won or lost. And you guys know this from reading cases. Here, as law students, underlying facts, then procedural facts, more or less detailed depending on the significance, right? And so underlying facts, what happened before you got to court, procedural facts, what happens after, you know, the complaint is filed, okay? For appellate work, standard of review, legal standard, and that, you know, again, there's both a procedural and a substantive element at the trial court level, right? It's a procedural standard, summary judgment, motion to dismiss, J&OV, whatever it happens to be, and your substantive standard. So it's this is kind of equivalent to this so-called standard of review, but you're not on review, okay? And the legal standard, so, you know, this could be pretty clear cut, or this could involve a lot of description and analysis. And essentially with a legal standard, right, and if it's clear, it's likely not resulting in a published appellate decision, right? So the applicable legal standard, you know, could come from a constitution, could come from a statute, could come from the common law. You might be looking here at legislative history, canons of statutory interpretation. You may be looking at, you know, sister jurisdictions. So, you know, again, in Vermont, if Vermont didn't have case law dealing with a particular issue, it was more likely to look at what Maine had done and what Massachusetts had done than to look at what Colorado had done or Texas had done. Okay, I don't know if that's as true now as many, many years ago when I was a law clerk, but you know, typically it's like you know how you have like Atlantic second, Pacific second, and you're typically looking to jurisdictions that are reported in the same reporter as you, okay? But that's up to your judge's preference. What else might come in here? You know, if you're going to talk about scholarship or treatises, which you really are, you know, mostly doing when there's an absence of law, that would come in here.
I'm looking at sister jurisdictions.
Yeah.
Like, how much would like a state court look to a federal court?
You know, not much. I mean, it depends, right? So it depends on the area of law, right? So state courts are typically looking at what types of claims.
Just almost like kind of, if it was kind of absent for some.
Well, the question is whether there would be anything at the federal level, right?
Yeah.
So federal courts sitting in diversity will have to decide these issues sometimes, but
it's even less likely.
they're going to defer to the states.
Yeah.
So it's really a matter, is it state law or federal law? So states are looking at contract law, tort law, common law, contract law, family law, state criminal law, state, you know, sort of agency law, and then, you know, things that arise out of state statutes. You know, on the federal level, it's really, and then, you know, state constitution. And they will also interpret the federal constitution. And in that case, two instances in which the state courts will very often look to the federal courts is, of course, when they're interpreting a federal constitution or, you know, for some reason, federal statute, but also if the state has a provision. Basically, there are some states that are kind of rogue states, like Vermont. Vermont's constitution adopted before the federal constitution. The language is different. Vermont really prides itself in its difference. is inclined to interpret the provisions, the analogous provisions in its constitution differently. Other states, there's a strong parallel between the state constitutional language and the federal constitutional language. Still, the state can either be, conforming to the federal interpretation or not. There's a choice there, okay?
And in the reverse, when a federal court is ruling on a state court issue, if it's not previously been addressed by the state court,
They should certify the question to the state court.
even district courts do they do that?
Yeah.
Okay.
You'll see that in our case. Yeah, district courts do that because they're not the authority on state law.
Okay.
Yeah.
So if they don't, I don't think this will come out, but then they just kind of
Well,
say that
either
they've
there's
done
guidance
it.
on the issue or there's not. If there's really not guidance and it's an important issue, they're
But wouldn't
gonna.
it be like how narrow or wide guidance is?
What do you mean?
Like if they haven't specifically addressed that issue, but their spirit of that law is
There will be arguments to be made there.
okay.
Right? But I think, federal courts are generally loath to interfere. They don't want to get in that mess of predicting what state courts would do.
Okay.
Okay. But you have that certification mechanism, right, where federal courts can certify issues down to the state court. I don't believe there's any reverse mechanism of state courts going to the federal courts. I've never heard of it. So, any other questions?
I guess kind of following up on that too, just to explore. If it's a state law question, but it's like, there's been a case on an issue in that district or federal courts, but not necessarily that state, would you still think they'd certify, or do you think they just apply that federal decision in a different state? I guess when it comes to state law.
The federal courts, they're not going to be the last word on state law at all.
Yeah.
You would never,
Just
you might say, you might refer to a certified question that was answered in federal jurisdiction, but you're never going to, I don't want to overstate it, but you're not going to look cite to the federal cases as interpreting state law because they shouldn't be actively, over-actively interpreting it.
Okay.
In this question of what's the substantive legal standard, what I really want to get you guys just to think about is this question of what law applies. Because we really don't talk about this enough in law school. And it's simply not always clear. Okay? That's a question that's on another, there's a question of what the substantive law, the content of the substantive law is, but an even larger question is what law applies. Okay, so in federal court, you're going to have that issue, kind of Erie doctrine stuff. And state court should be clear, but it's just something to be aware of. And again, not necessarily to trust the parties on that. Not to trust the parties on the standard of review. You definitely want to make an independent inquiry into that. Okay? Anything else?
What
Yeah.
is app?
Application. So whatever legal standard happens to be application to the facts. And this should be less controversial because in some ways, I don't know, it's kind of hard to characterize it that way. For the district court, for the trial court, a huge part of your job is fact finding. Obviously, that was a huge part of the job for the district court in the Perry case. And then you apply the legal standard to those facts. The facts are pretty set, should be pretty set by the time you get to the appellate court. So then the question is typically, a mixed question of law and fact of, again, either it's clear or it's something you have to kind of persuade people of, that the application of the legal standards of the facts counsels for a certain result. Questions, comments? Okay, so let's go ahead and talk about the district court's decision in what was, at the time, Perry versus Schwarzenegger. So, district court level, Perry versus Schwarzenegger, Ninth Circuit, Perry versus Brown, and then the U.S. Supreme Court It is Hollingsworth versus Perry. Can somebody explain the difference in the case names to me? It was funny, so this Forgetting Romer article, essay, there was like some comment in response, and the person was like, I wish we could all agree to call the case Hollingsworth, because Perry is such a common name. And for me, it's like, well, Perry's the only party that, that it's only, to me, clear what you're talking about if you say Perry. But anyway, what's happening with the case caption?
So Perry is one of the plaintiffs, and Schwarzenegger was the governor of California. And then Brown is the attorney general, or is that a different Brown?
It's a different Brown.
Okay. He was the governor.
Exactly, so he was the governor later, yep.
And then Hollingsworth is one of the proponents.
Yeah.
So when they lost, they appealed it to the U.S. Supreme Court.
Yeah, okay, so what happens is, the same thing happened with the Defense of Marriage Act. Eventually the government backs down, the executive branch backs down and says, we're not defending this law. And I think I already mentioned to you that so there's a standing ruling in each case. And the Supreme Court sua sponte added that to the list of issues to be addressed upon hearing certiorari. Okay, they want to address standing in both cases, and it's just. Did we talk about this a little bit? It's not the same as between the DOMA case and the Proposition 8 case. So the Windsor versus United States is the DOMA case that the court accepted certiorari on, but it's not the only DOMA case out there, right? There were DOMA challenges pending in multiple different, both district courts and circuit courts of appeal, and so you have. I mean, this is the discrete. This will be over. Most likely, after the court decides Windsor. The holding in this case applies to DOMA, and it's going to deal with all the DOMA, the pending DOMA litigation. Okay, so all that stuff has been stayed. The Prop A case, not necessarily. It's not. I mean, there are other state challenges out there. I don't even know all the states. I want to say New Jersey, Arizona, Hawaii, other places, and this is one of the things I need to be updating myself on in the next couple of weeks, actually. But the resolution of the Prop 8 litigation may or may not affect, but these are all different state laws, right? Statutes, constitutional amendments, popularly enacted by the legislature, state court rulings. It's really a lot of variety in terms of how the states deal with the same-sex marriage issue, okay? So depending on how the court deals with Proposition 8, that holding may or may not govern the outcome in all these other cases. There are a lot of people who think the court's going to try to decide in a way that doesn't implicate all the other cases. But the standing issue, so what you have in the Windsor case is you have, and I gave you guys this article, and you don't necessarily have to read it. But you have the executive branch refusing to enforce this law. Refusing to enforce it, but also refusing to defend the law at the appellate level. Okay, there was a change in course. There was this memo by Eric Holder saying that sexual orientation should be considered suspect classification. They're not going to defend it anymore. And so BLAG, which I want to say like Blarg or something, it's just such a funny name, the Bipartisan Legal Advisory Group kind of takes up the flag. And the question here is, do they have standing to do so? Okay, so issues around standing is you have to have concrete injury, etc. And there's this whole aspect of congressional authorization here. Okay, in Prop 8, same thing is that you had, well, it's similar in the sense that the proponents of DOMA, that was Congress, right? And then BLAG is taking their place, or rather Congress as represented through BLAG is taking the place of the executive. Same thing with Prop 8, except the proponents are literally the proponents of Proposition 8, placing it on the ballot. And the California Supreme Court ruled on this issue as a matter of standing under California state law with respect to how these groups sort of operate and what their interest is in particular litigation. So I think that's going to be kind of off limits for the Supreme Court, but this is in the Supreme Court's wheelhouse, right? This is for the Supreme Court to decide this question of standing of a group that purports to represent the interests of the federal Congress. Okay, so you don't need to understand all that, but just see there's a distinction. Go ahead.
So if, so the California Supreme Court already ruled on Prop 8, and you were saying that the...
Not exactly,
well,
but...
Okay, they
yeah.
ruled on California state law, but if the U.S. Supreme Court, when they rule, they kind of narrow it to California, and we don't know if it'll affect New Jersey and Arizona and Hawaii, why would they have accepted cert if they're going to limit that holding that much?
Because the Ninth Circuit arguably engaged in a radical interpretation of the federal Constitution. There may be conflict in the circuit court. There already is some conflict vis-a-vis the outcome of various state law challenges. Okay. California Supreme Court said under California Constitution you have to allow same-sex marriage. Okay, not just civil unions or domestic partnerships. You have to allow same-sex marriage. Then Prop 8 was enacted. There was essentially a procedural challenge to Prop 8. The Supreme Court, the California Supreme Court, upheld the validity of Prop 8. So the nature of the procedural challenge was sort of, this is not the type of amendment that's permitted to our Constitution. Does that make sense? I mean, I'm not deeply familiar with this, but it was essentially, there's some kind of limitation on types of amendments that you can make. Supreme Court says, no, this is actually permissible, but in this decision, the court described the exact scope and effect of Prop 8. And that is binding on the federal courts because it's the state Supreme Court interpreting state law. Okay? Then, so there's this decision, and then on a certified question from the federal courts, California Supreme Court said proponents have standing.
For the state constitutional
For the federal challenge. So, sorry. So after this decision, after the attempt to invalidate Proposition 8 under state law in the state courts failed, that's when federal litigation was filed.
Is that this opinion where they?
Mm-hmm.
And they, okay, I'm curious. So
No, that's good. We should get this straight.
the California Supreme Court said that they have federal standing. How can they do that?
The standing issue, so
Because
there's
it's
a
a federal
federal standing standard, right, about, you have to have an actual injury that you're seeking redress for. Well, this is perfect, actually. Okay. Issue is their standing. Rule, and I'm sorry, I don't know the precise articulation of the rule. Does anybody know the precise?
Something cause injury, cause or redressability. For constitutional standing, not prudential.
Okay, so then, what's the next issue? Is there an injury? This is governed by California law. When proponents of a ballot measure suffer injury. Does that make sense? So this embedded issue within the federal standard is determined by California law.
And that's a federal rule.
This is a federal rule.
Well, yeah.
This is a
injury,
state law rule.
But, I mean, how could I guess my problem is, how can the California states determine whether somebody has an injury as a matter of federal constitutional law?
Because there's not, I'm not sure, because to me that's like crystal clear, but obviously it's not crystal clear. I'm trying to think of another example. But the idea of whether you have a stake in the outcome of particular litigation is just, that's not necessarily an issue of federal law. That could be an issue of state law, right? So in one state, the rules around election law, and we'll get into this when we read the Ninth Circuit decision, but the rules around election law could divest the proponents of any interest. In another state, they have that interest. So it's really,
Okay.
I'm trying to think of a better example.
I get it.
But
It just doesn't seem very intuitive to me.
Yeah, no, this is a good example of that relationship between the federal courts and state courts and federal law and state law, okay?
So the same thing could happen in a contract or anything, right? Where it's like, is there an injury? And then depending on the state law interpretation of that, either there's
Yeah.
an injury.
But contract is a matter of state law anyway, so it wouldn't be about interpreting it in a federal context unless there was a federal right to a cause of action.
Standing is the federal, there's a federal rule for standing.
Yeah.
But embedded within that is reference to state law rules about injury.
Yeah, okay.
If that makes sense. But we'll definitely unpack that when we read the Ninth Circuit decision. Okay.
Professor Paul, what
yeah.
does that say standing for federal?
Standing.
Okay.
Sorry, I know, this is horrible, right? Where are you?
So like right where your hand is? Standing.
Certified?
Trails off.
Certified proponent.
Has standing for federal
Jolly.
challenge?
Challenge.
Federal
Okay.
challenge?
Okay, thank you.
Okay.
I knew what you meant, I just didn't know.
No.
Wait, no, sorry, I'm confused.
Go ahead.
Just in terms of where the parties are. So California Supreme Court certified that the proponents have standing for a federal challenge, but here it's...
To defend it.
Oh,
No, that's right, that's right. And they have standing to defend it on appeal.
Okay.
Now, why would California do that?
Why would they say
I mean, that's what the law says, right? So that's worse.
I have another question.
Yes.
Just kind of procedurally,
Just one more.
Okay.
And that means, so they're the defendants, or they're the appellees, they're the appellants at, the defendants at the trial court level, but then the appellants at both the Ninth Circuit and the Supreme Court level.
Okay.
So they're not challenging the law, but they are the ones who have the burden of moving forward with the case.
Okay.
If that makes sense. Go ahead.
So in the opinion, in the district court opinion, he says that the federal, went through California, blah, 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 and then for the first time, the federal constitutional issues were raised here.
Yeah.
And so, but if they had raised, this is just kind of a procedural thing in my
No,
mind.
that's
If
great.
they had raised the federal constitutional issues throughout the California state proceedings,
Where would they go? On
they would
appeal?
have to go to the Supreme Court.
Yeah.
So do you think that that was a planned decision?
Absolutely. I mean, all this, and that people didn't necessarily have consensus
Uh-huh.
on, and let me just say that if it was fully litigated as a federal constitutional claim in the state courts, yes, it would have to be appealed to the United States Supreme Court. There are some times, and I really don't know a lot about this, there are some times where it can move laterally over to the federal district court, but I couldn't really describe to you what those circumstances
Like under
are.
removal, or?
Yeah, and I just don't, I've never really dealt with that issue of litigation.
Because I kind of feel like there should be a rule against that. I mean, obviously it was strategic and they wanted,
Like collateral
You know,
estoppel, like you should have brought this
or
up
like
when you had
res
the chance.
judicata.
Yeah.
I mean, why didn't you bring it up when you clearly were developing?
So, it's a great question. So the idea is, right, I've suffered injury, I go to court, I bring a battery claim but not an assault claim, right? And I lose, and then I try to refile with an assault claim, right? And you're not permitted to do that because it's a waste of judicial resources, it's a waste of the opposing party's time. If you had the opportunity to bring an issue up, then you should do it. These are, well, this is a fundamentally different type of challenge than the federal constitutional challenge. I mean, I think that maybe is part of the issue, is that, that was a narrow state law procedural issue, and that did not necessarily, and this is kind of, I'm just speculating, but it did not necessarily imply that they should have litigated the federal constitutional claim at the same time. Because if you could win on narrow state grounds, why would you open the can of worms of federal constitutional claims? So that's, at least theoretically, a valid basis for distinguishing that situation from, like, I would bring a claim for battery but not assault.
Or a claim for state constitutional and then go to federal
So and why can't they, the same thing with Amendment 2. So that's what happened with Amendment 2, is first, Colorado's Amendment 2. Litigated, I want to say under both the Colorado and the federal constitutions, all the way through the Colorado state system, and then it went to the United States Supreme Court. So you can, setting aside the fact that they brought this procedural challenge, you can obviously choose to pursue a federal constitutional claim in either state court or federal court. It is my understanding, without having, tons of access to what's going on in this advocacy community, that, the strategy generally has been stay out of federal court, stay out of federal court. We don't like the Supreme Court right now. State courts are friendlier. And that, David Boies et al. Kind of went ahead and did this anyway, despite the fact that a lot of community members were not necessarily behind them. So they could have brought it in either state or federal court, and they chose to bring it in federal court.
Okay.
To really push the issue, I guess. And then I saw Judge Reinhardt on the panel, and they were,
Yeah, also, that's what I was thinking. Maybe he was also maybe a little more willing to overlook.
what?
I mean, I think that it should be some type, or not.
There are principles involved. I don't know, all the precise doctrine around it, collateral estoppel and res judicata, but there are principles that determine when you should have brought that claim in your first round and when you shouldn't.
Yeah.
So, does everybody kind of understand what we're talking about? Okay. All right. And again, what we're focusing on now is the challenge under the federal constitution in the federal courts. So it's helpful to understand that there is this background, but, we're focusing on this one piece of the litigation. So, talking about the district court decision today, we're going to focus on the court's conclusions of law, but that's really the minority of the bulk of the opinion, right? What's the bulk of the opinion? Factual findings. Extremely detailed, thorough factual findings, which is something everybody commented on when this decision came out, right? As a smart move on the part of the district court, and again, this is from the perspective of advocates of same-sex marriage. Why? Why is this a smart move?
Well, we talked about standard of review issues with this. All this stuff's almost set in stone.
Theoretically, right? So this is a supercharged, political, divisive issue. I'm going to make it about findings of fact. Okay, all these kind of policy questions, are civil unions symbolically equivalent to marriage? I'm going to make that as a finding of fact. Okay. What happens to these beautiful findings of fact, these careful findings of fact on review at the Ninth Circuit? Okay, you haven't read it yet. I taught.
Good.
No. I took over a class for Professor Smith because she was out of town, and they have a 2.5-hour class, and so we did the district court decision and the Ninth Circuit decision in the same class. I forgot you guys hadn't read it. Just by way of preview, the Ninth Circuit says, there's an issue about the standard of review, and an issue as to whether the district court's findings were adjudicative facts. We talked about this the other day, or legislative facts. Okay, who, what, where, when, versus policy issues, issues of, you know, social meaning. Okay, so the district court did this really brilliant thing, and the Ninth Circuit's like, well, we all know you're not going to get away with it that easily, basically. And then, excuse me, the Ninth Circuit says, we don't have to decide which of these categories these factual findings fall into, because we're only going to look at this small set of factual findings that are clearly adjudicative facts. Okay, and they push everything else aside. And we'll review that again when we talk about the Ninth Circuit decision. So what is the first legal issue that the district court addresses?
Due process.
Okay. Right, and then, you know, generally with constitutional claims, especially due process equal protection, you have to determine the level of scrutiny before you address the merits, right? So what's the level of scrutiny rule that's applicable here?
Fundamental right is, I don't know, impacted is what? Yeah.
I know impacted is permissible usage now, but
A fundamental right
really,
is
it's
what?
like, no!
I didn't know what verb the,
Implicated?
burden. Well, this is a whole separate question too, but because lots of things can be implicated. A smaller set of things might be burdened, and that burden right has to reach a certain level. Okay, so what then is the next issue? I don't think I've done any nested IRAC stuff with you guys, but this is how I diagram, sort of functionally diagram cases.
Is marriage a fundamental right?
Is there a fundamental right at issue? We know that marriage is a fundamental right, sort of writ large, but right, that's an established rule per Loving, per Zablocki, right? But what's the issue? What's the unresolved issue?
Do same-sex couples have a fundamental right?
Oh, okay, so that's very interesting. So I phrased it as our plaintiffs asserting a right to, now I start using quotation marks, marriage. Or some courts have framed it this way: is there a fundamental right to same-sex marriage? Or, I love that you did this, Kara, do same-sex couples have a fundamental right to marriage? And let's do a little thought experiment. Let's articulate the three variations of this question in the context of Loving versus Virginia and anti-miscegenation laws. Okay, so first is the same. What's the analog for the second question?
is there a fundamental right to interracial marriage?
Okay. What's the analog to the third question?
Do couples, interracial couples have a fundamental right to marriage?
What's the trade-off between those different formulations?
Isn't it just how narrow, or what do you mean trade-off?
What's the question as to whether there's a fundamental right to marriage? And what's the answer? Sorry.
Yes.
Hell yeah, right? Is there a fundamental right embedded in the Constitution to interracial marriage? No. Do interracial couples, does the Constitution confer upon interracial couples a fundamental right to marriage?
Yes.
No. What does this sound like? The issue framing in what case that you guys have read?
Bowers.
Yeah. And what, so to me, what makes the difference is, and this is, you know, I'm riding my hot horse here, and this is something that really intrigues and disturbs me, is framing the fundamental right question with explicit reference to the historically excluded group. Of course, the historically excluded group
Has not
doesn't-
historically had.
right? You know, and the same thing is kind of an issue here. I think these two things are equivalent in a sense, right? That if you say, well, the question's not whether there's a fundamental right to marriage, the question is whether there's a fundamental right to same-sex marriage, what you're really doing is placing the lens on the disfavored, unpopular, excluded group, which kind of tips the scale a little bit. But that's exactly what the district court is engaging in here. This is a path that many other courts have gone down. The district court in Hawaii, the Jackson case, looking at a state law challenge there as well, asked and answered this question. Without really explaining why that's the proper formulation of the question, okay? So, rule. The rule that the court articulates here is not actually really directly responsive to this. The court says, invokes the rule for determining a fundamental right. The rule invoked in Bowers. But what gets interesting is the court's, and I think very smart in terms of really unpacking this inquiry, right, is the application. And the court essentially says, maybe this is also a sub-issue, but we'll stop for now. In its application, it essentially answers the question, it disaggregates the various components of marriage. And it asks, essentially, this is not the text, or exact text it uses, but what aspects of marriage are fundamental? Right? And there's some that are fundamental, and there's some that are not. Fundamental. 2 parties. Step off polygamists, right? Consent. Not that deeply rooted in history, but consent certainly has a recent history of being important. Formation of a household. And the state regulates this institution of marriage to foster what? You guys remember this?
Stable households.
Yeah, so social stability. There was another really excellent term in here. That, if anyone was
Stable, governable populace.
yeah, we'll get to procreation. A governable populace. What? You become so docile. Not happy once you get married. You become very easily governable. That's a pretty sinister characterization of marriage. Non-fundamental procreative ability. Not to say there's not a connection between procreation and marriage. There is, but the state has never regulated it with respect to procreative ability. I mean, no other court has really parsed the marriage issue this precisely. Okay? Choice, that's fundamental. Privacy, that's fundamental. This is all in the fact findings. That's, again, what's so brilliant, right? From a perspective of appellate strategy or anticipating appellate strategy.
What's the difference between choice and consent?
Choice of marriage partner. Consent, you can't be forced into it.
Okay.
Which, of course,
Choice of marriage partner to some extent.
yes, right? That's a big looming question out there. subordination of women. Part of the history, but not a fundamental aspect of marriage, right? Gender roles, differentiated, gender roles. And the court concludes that the exclusion of same-sex couples is but, artifact I. Thank you. Artifact of this. Making a link between sex discrimination, subordination of women, and exclusion of same-sex couples from the institution of marriage, all based in factual findings.
I wrote loving in there too.
Go ahead.
I mean, he kind of rolled race and gender in together as artifacts to get rid of.
So,
Not essential.
So, there may have been a tradition of single-race marriage, but when you look at the core values of marriage that really are transcendent beyond historical time period, that doesn't persist, right? Neither do gender roles. Without gender roles, without prescribed gender roles, no reason to exclude same-sex couples. Same-sex couples and opposite-sex couples are identically situated vis-a-vis the rights and obligations of marriage. Okay? Why is that language identically situated? Why is that important in terms of equal protection doctrine?
Similarly situated in videos, discrimination is the standard.
Okay, yeah, so sort of as, Claiborne being the case that's most often cited for that proposition, the Equal Protection Clause is essentially directive, I don't think it uses that word, that similarly situated individuals be treated alike. Okay, so if they're identically situated, they should be treated alike. Okay? So I think pretty interesting sort of fact-based, fact-finding-based reasoning there. Okay? So, conclusion is that, fundamental aspects of marriage, do not relate to gender roles, do not differentiate same-sex couples from opposite-sex couples. There's one right to marriage. Same-sex couples and opposite-sex couples have an equal entitlement to access that right. Okay, and if you remember, Bauer said, does the Constitution confer upon homosexuals a fundamental right to engage in homosexual sodomy? Kind of a loaded question. And the Lawrence Court said that homosexuals have the same right as heterosexuals to privacy and intimate relations. Okay? Same inquiry framed and resolved differently. So there's a lot at stake. And you think about ethical judicial opinion writing, what we talked about there, there's a lot at stake in terms of how you frame the issue. So, yes, we have a fundamental right involved here. The next issue, is it burdened? Okay, we talked about what verbiage was important there. The idea is that fundamental right has to be burdened. And the court doesn't really state its rule here, but says, the mere existence of, I guess it's civil unions there. Civil unions, they're not equal to marriage in terms of status, dignity. You know, and this, you see this phrase over and over again. The evidence at trial shows. Sorry, it's not civilians, it's domestic partnerships. The court says, you know, domestic partnership system exists solely to differentiate same-sex couples from opposite-sex couples. Okay? Yes, burdened. What's the rule? What's the unarticulated rule here? So the argument is, well, you know, when you have domestic partnerships, excluding same-sex couples from marriage doesn't burden the fundamental right to marriage because they have all the incidents of marriage, right? All the rights that come along with marriage.
So,
Separate, but he
Yeah.
is inherently unequal.
Exactly. That's the missing kind of principle. Okay. I don't care if all the tangible substantive rights are the same. State, by separating these groups into two different institutions, you're expressing that one group is lesser than the other. And that's impermissible under Brown versus Board of Education. If you take Brown versus Board of Education to apply to segregation beyond racial segregation, okay, which not everybody does. Then the question is, does Prop 8 survive strict scrutiny? And the court says it doesn't even matter because it fails under rational basis review. See below. See below being the equal protection argument. Okay? And so I'm kind of modeling for you guys, you know, kind of how I dissect cases here and want to, you know, do the same thing on Monday. If you can kind of diagram the Ninth Circuit decision this way, and that's going to give you a really good starting point for drafting that section of your opinion where you talk about concisely what the district court did and what the Ninth Circuit did. Okay? Does this make sense, this type of IRAC mapping? Okay. So, the issue is, does Prop 8 violate the Equal Protection Clause? Okay, rule the court cites is even under rational basis review. So obviously, if you fail rational basis review, you fail them all. It's the most deferential, okay? Even under rational basis review, a law must do more than disadvantage a group. What does that rule mean to you?
There has to be a reason for a discriminatory law rather than to just disadvantage. Rather than to just do it out of city decision.
Okay, so in the language kind of of loving, there has to be some reason for it independent of invidious discrimination. Which to me leaves the question open, okay, well what if one reason for the law was to disadvantage a group? Explicitly that was the reason. But hey, it also saves tax money. Or, you know, or it advances, you know, some form of social welfare. Is that law really okay?
On the rational basis, yeah.
And yet, when the court finds this in Romer, in Claiborne, in Palmer versus Sadati, in Moreno, there are plenty of rational bases. There are plenty of independent rational bases for the law, but the court still strikes the law. So, in terms of what the court says, a law should survive rational basis review even if it purposely disadvantages a group, so long as there's this independent basis. In reality, it doesn't play out that way. Okay, so the court does say, what do you make of the fact that the court says they're entitled to strict scrutiny under the due process prong? They're probably entitled to strict scrutiny under the equal protection or classification prong, but it fails under rational basis review. What do you make then of those first two assertions that heightened scrutiny is available? Is that good judging? Does it violate any principles of good judging?
Seems a little lazy.
It's all.
That's interesting, okay.
Well, isn't it
I'm
not saying this-
advocating because it's dicta?
I'm not saying this whole opinion is lazy. Clearly, it's not because it's super
No,
long.
no, no,
But
no.
like, not even attempting to discuss how the outcome would be under strict scrutiny. Or is it that they were trying to be careful and not do that because they'd be more easily overturned?
I thought he was just advocating that it should be a protected class. Like,
But why would he even talk about it? It's a constitutional issue.
To get strict scrutiny, right?
Why would he even talk about that if he's not going to apply it?
because in case another court,
What is that?
Cover your head.
Okay? So it's problematic because it's dicta, it's problematic because it violates the principle of constitutional avoidance. Do not decide constitutional issues like whether a group is a suspect class, whether a fundamental right is implicated, unless you have to. If the court had gone through and solely relied on strict scrutiny, what risk on review?
they would say that
But they would choose a different.
if they chose a lower, then they could just dispose of it.
Yeah, and there's nothing in there, right?
Yeah.
If the court didn't address the basis for heightened scrutiny, what risk?
Then they would say that it's not a protected
Available.
class.
Then the district court wouldn't have passed on that fact-intensive inquiry, right? So the district court is seizing its opportunity here to make, ooh, I'm going to do it, very impactful findings. I can't believe that word popped in my head. If you take away the the analysis for why heightened scrutiny should apply, the district court never gets to speak about that issue, put its sort of imprimatur on the case. But if the court ends applying rational basis review, the district court, I mean, this is rank speculation, but the district court wants to say, clearly based on all these facts, it doesn't survive rational basis review, okay? So when you see those principles of constitutional avoidance being violated, kind of ask yourself, well, why? You know, judge is sitting there with his law clerks, why did he decide to go this way?
This was especially funny because they made such a point of saying it didn't matter if it's not.
And that should set the bells off, right? There's something broader going on here.
And what does LOS stand for?
Level of scrutiny.
Okay.
But you got the acronym that mattered, so. Okay, so if it's sex discrimination, you get heightened scrutiny, intermediate scrutiny. If it's sexual orientation discrimination, you have to ask, well, is this a suspect class? Right? And what does the court conclude applying what rule?
He says that it's gender or sex discrimination, sexual, yeah. But I'm
So this is
confused
settled.
by this too, because he basically says that, where is it? The claim is based on sexual orientation, but this claim is equivalent to a claim of discrimination based on sex. So is he saying that it should also be subject to intermediate scrutiny?
That's another basis for heightened scrutiny, is saying
You're saying
it's
it's
sex
both.
discrimination. I think it's more clearly sex discrimination than it is sexual orientation discrimination. I mean, the facial classification does not refer to sexual orientation, it refers to sex. But courts don't see it. We talk about this, what courts do with this argument, they say, well, men and women are treated equally, so it's not sex discrimination. That's not the standard for when something is sex discrimination. The standard is whether there's a facial classification based on sex.
Okay.
But what's interesting, I think, about the district court's approach is that he contends it's sex discrimination for two reasons. One, facial classifications, he doesn't really get into that. But two, the whole premise that you need, that there is a rational basis for preferring opposite sex couples over same-sex couples is that they are substantively different, meaningfully different, which necessarily implies gender role differentiation. So it's substantively, not just formally sex discrimination, but also substantively, in terms of the ideology that's expressed. So, you know, the suspect classification criteria, history of discrimination, politically powerless, discrete and insular minority, there's relationship to ability, relationship between the trait and ability to participate in society.
But he doesn't, does he do that?
He doesn't go through the entire sort of vigorous suspect. He focuses on, he talks about this, and the fact that the defendants conceded. This is really different than what would have happened 10 or 15 or 20 years ago. Conceded that there's no relationship between sexual orientation and ability, so to speak, right? So where did these criteria come from? You guys remember? Does the phrase filled milk
It was that
ringing bells?
It was the
Your
one-
reaction was appropriate. Caroline products.
Yeah.
Footnote 4. And you'll remember in the ethical judicial opinion writing article, the authors talk about how this was drafted by a law clerk. It's a case about whether it's unconstitutional to discriminate between different types of milk products. And there's a footnote, an extremely brief footnote, that says, you know, we're applying rational basis review here, but we should probably apply a little more scrutiny in these cases. Boom, boom, boom. The footnote to a filled milk case is the basis for contemporary equal protection jurisprudence and its doctrinal structures. Okay? That just kind of blows me away. And then this criterion sort of developed in conjunction with recognizing gender as a quasi-suspect classification. Okay, and it's reiterated in Claiborne.
Yeah, military side.
Yeah, so there's Frontiero, JEB, which is jury case, and then VMI.
No, that's different.
That's the Washington v. Davis, I think.
Probably.
For firefighter exams. Yeah.
Oh, yeah.
Okay, I'm not going to indulge in this habit I always have of keeping you guys late. So, essentially, now we're going to turn to this rational basis analysis, okay? But so the court goes through all this work to kind of set this up and sets forth two arguments for heightened scrutiny, and then goes to rational basis review, okay? Smart in a lot of ways, you know, sort of strategically smart in terms of covering all the bases and anticipating. You know, if you look at Romer, the court went to rational basis review in Romer to avoid precisely these questions. You know, will the court do that in 1996? Will it do it in 2013? We'll see. And there's a debate going on about, I feel like most scholars are anticipating that the court will engage in suspect classification analysis, which is interesting because, you know, that's not the basis for the holding, either the district court or the Ninth Circuit opinion. And you have, you know, Kenji Yoshino on the one hand saying the court is not going to recognize any more suspect classes because the court has this status or the pluralism anxiety about the multiplication of groups in society, and what, you know, it seems like everybody could be a suspect class, right? We're not going to recognize anymore. And the court hasn't recognized a new suspect class for about 4 decades. They've rejected a lot, but they haven't recognized a new one since then. And then on the other hand, you have Bill Eskridge saying the time is now. That sexual orientation will be recognized as a suspect or quasi-suspect class, and it will be in the context of the marriage equality cases. So it's going to be super interesting to see how it actually turns out. Okay, so we'll stop here, go through fairly quickly through the district court's rational basis analysis, and then we'll look at what the Ninth Circuit did, which is really different than what the district court did here. It went in a really different direction. Okay, any questions?
That's just, so defendants concede, what does it say?
That there's no relationship between sexual orientation and ability.
Okay.
The defendants here conceded that point.
Okay.
Okay. Which again, like I said, I mean, the original defense of the Defense of Marriage Act, it's appropriate to disapprove of homosexuality. The defense today, we need marriage to constrain irresponsible heterosexuals from producing out of wedlock, producing children out of wedlock. Very different argument. It's really evolved. Not in the sense of being better or more sophisticated, it just it's changed and drifted over time. I gave you guys all the receipts and stuff, right?
Yeah. Nice.
Yeah.
Oh, I'm so sad that I'm gonna have bangs in mine.
They still haven't come to mind. I can't believe it.
I mean, now I'm like not so upset. I'll go out in public, but still thrilled.
You just gotta do more crazy things to your hair and not care about it, and then you'll become totally immune
Yeah.
to any concerns like that. Okay, guys, see you next week.
Bye.
Bye.
That's what mine started off with, like when I was down here.
Yeah.
Oh, yeah.
I had it all in my head.
Yeah, you just have the decimals in your head. Yeah.
You just need to get hers just so you can compare theirs, just in case there's like.
Yeah, yeah.
Yeah, we should probably do this for the rest.
And she said no.
Did you drink this thing?
Hornums, pretty high. Hornums like the top 30.
I was trying to remember that when I saw it.
Yeah.
It's nice placement. for
Yeah.
it.
I think addiction is the title of the article.
What is it called?
Constitutional animus.
So.
I think
Well,
when
it's
she
like,
had
is
that
this supposed to
list
say
of-
animals? I think you have a typo.
She had that list of Romer, she had those other ones where they had overturned stuff.
Yeah.
I think those are the cases that she links together in that she argues are all
Oh,
animus.
Okay,
yeah,
I've
you
actually,
see
I've
it
actually
right
right across the street from
Yeah.
for 10 now. I've
Or
been,
was
A
so
year
that
ago.
like
whoever it
Yeah.
is, must have just gotten the address
Are
wrong.
you relinquishing your duties yet?
I'm sorry about that,
Yeah,
but I
almost out of the woods.
will actually
Gotta
come in about half an hour.
Giving
and just
information to the
go.